Welcome to the Art of Arbitration, where we explore the world of ADR. Today, I'm privileged to be speaking to Daniel Lim from the law firm of Joyce A. Tan and Partners in Singapore. Welcome, Daniel, and thank you for speaking to us today.
Thank you for having me, Brett.
So let's talk a little bit about your firm, what you do, and what your personal specialty is.
So Joyce A. Tan and Partners was started by Joyce in 1998. So this year we are into our 26th year. I joined the firm about 11 years ago, and my practice then, as well as continuing on today, has primarily been on dispute resolution. Otherwise, the firm is a full-service law firm.
So you talk about dispute resolution. So I assume that covers the gamut of litigation, arbitration, and in-court litigation, correct?
Yes, so the whole gamut, as well as mediation, it's essentially assisting clients who have problems to solve them.
So talk about the type of clients that the firm has. Well, what are the general clients that your firm sees? Are they internationally based, Singapore based entities doing business in Singapore? Just give me a bit of information about what you normally see come in the door.
Yeah, I think it's true throughout all our different practice areas that it's generally going to be about 50-50 mix. It's been true all the years that I've been here. So whether it's corporate transactions, it's going to be 50% overseas, 50% local. Disputes wise as well. So I see a lot of international work, cross-border disputes on both sides, whether representing foreign clients or local clients or sitting on the other side of the table.
So when you talk about cross-border disputes, are you seeing cases where the law that applies is Singaporean law, or are you seeing cases where the venue or the situs of the dispute is intended to be in Singapore, or both?
So it'll be the latter. It's not necessarily the case that the law governing the contract is Singapore law. By virtue of the venue, that's going to be the majority, but not always. So whether it's in litigation or in court or whether it's in arbitration, we do see laws that are not Singapore law being used and argued.
So when that happens, do you generally work with counsel from the jurisdiction where the applicable law is?
We can, and when it comes to litigation, it gets more formal and more involved because the foreign law will be regarded as expert evidence. But in arbitration, it's a lot more relaxed. That isn't a problem with me, a Singapore lawyer, presenting to the arbitrators what we say the position in, say, Indonesian law is.
So let's talk a little bit about arbitration in Singapore. Singapore has become a hub of international arbitration. I believe that international arbitrations, the two largest venues are London and Singapore. Why has Singapore become such an important hub for international ADR?
It's intentional. So there was a lot of intent behind it. Having said that, there was a strong foundation of very good counsel in Singapore, high quality lawyers, as well as high quality judges. And before my time, they got involved in international arbitration. And eventually, when I say intentional, it would be from the government support. And it was a typically whole of Singapore effort in the kind of things that Singapore does. So ground up, top to bottom, intentional effort. It required legislative change. It required facilities. It required investment, making sure you've got the right people, networking, marketing, making all the effort to line up the ducks and put things in place. So it's very intentional.
So let's talk a little bit about that intentionality and some of the specifics of it. I understand that the country actually passed very specific pro-arbitration legislation, which among other things limited the right to appeal. In other words, that unlike some other jurisdiction, a mistake by the arbitrator isn't a right to appeal. You can only appeal for excessive, improper jurisdiction or something unfair in the proceeding. And that was a change to the law, and that was one of the steps, the procedural steps that made arbitration in Singapore grow. Is that fair?
That would be an important aspect, the legislative change, where usually the courts have, when I say usually before the legislative change, the courts would intervene where there was a mistake as to law. So that was removed in Singapore, and which is really giving credence and weight to party autonomy when you decide arbitration is the way that you wish to resolve your disputes. Then the arbitrator has got a very strong final say. So yes, the grounds of appeal tend to be only on excess of jurisdiction, which is a very rare thing because the tribunal themselves have got competence to rule on their own jurisdiction, and that is very much respected. And the other aspect would be breach of natural justice, something unfair in the proceedings, and that is very difficult to prove. The vast majority of cases that people do bring to the courts on appeal fail.
So you said, let me follow up on one thing. You said that arbitrators, the tribunal, can rule on their own jurisdiction. So if a party files a case in court and the other side says you can't file a case in court, we have an arbitration provision, who decides whether the arbitration provision applies? Does the court automatically send that to arbitration if it finds that there is an arbitration clause, and then decide whether this is within the jurisdiction, or does the court make that decision before they send it to the arbitrators?
If there's an arbitration clause, an arbitration agreement, and one of the parties says this needs to go to arbitration, the courts will very likely stay the court proceeding. The court is not in a position to initiate arbitration. Basically tells the parties, well, you have to start arbitration first. If there's a jurisdiction issue, the tribunal will have to rule on that first.
Interesting. So I want to go back to the government purposefully making arbitration easier and better in Singapore. I understand that not only did they do it on the legal procedural side, they actually did it on the economic side. For example, if you are an advocate in Singapore, you do not get taxed for the work you do in Singapore. The arbitrators don't get taxed for the work they do. They make it very easy. If you're country where visa is required, to get a visa if you were working on an arbitration, things like that. They basically made it as easy as possible for the parties and the arbitrators to work in Singapore. Is that correct?
Yes, if you need to, if you don't have visa free travel to Singapore, I just read the other day that Singapore has the most powerful passport in the world. You only get there by being reciprocal about it.
Sure.
And so you can obtain visa on entry. The work that the Foreign Council as well as the foreign arbitrators do when they come into Singapore, they're not going to get taxed in Singapore for that. There's also the setting up of organizations, facilities. The SIAC is intentional as an organization in the support that they get. A lot of the arbitrations are centered in a facility that we call Maxwell Chambers, which is it's a very nice colonial building. It was very nicely done up, continuously being refurbished and improved upon. They put in the best facilities. They make sure they get the right support people. Yeah.
So
That's in addition to the fact that Singapore is a trade hub. So you already have the fact that the airport is so well connected to the rest of the world, and travel to Singapore is very easy.
And I think one of the big benefits of Singapore is it has really an international trust in the system. It does business with everywhere in the world, which is not true in a lot of our countries. And I think people will agree to arbitrate in a place they consider to be fair, honest, and have laws that will be enforced. So I think that's a big advantage to Singapore. You mentioned the SAIC, which is the Singapore International Arbitration Center. That is a private organization, correct?
Gosh, I don't know the answer to that question.
Well, what I mean by that is you're not doing it within you're not arbitrating within the judicial system.
Yes.
Right. It is an organization that is government funded in Singapore and marketed by the government, again, showing that government is pro-arbitration. But that's where a lot of the arbitrations are centered in Singapore, is through the rules and the facilities of the SAIC, correct?
Yes, that will be the majority. But the SIAC comes into play usually when parties specify that in the contract, or even if they don't, they decide that they want to send it to the SIAC. But having said that, if the SIAC hasn't been designated, then the parties are free to convene an ad hoc arbitration in Singapore.
So the SAIC is centered in Singapore, is headquartered in Singapore, but they do have, my understanding is they have offices throughout the world, India, Geneva, Shanghai, Seoul, New York, so that you can have an SAAC arbitration, but there are other locations where you can have it, and that actually, I believe, Indian law and Indian lawyers are one of the largest users of the SIAC rules and arbitrators. Is that correct?
Yes, but I think that a lot of the council and arbitrators enjoy coming to Singapore as the physical venue. I think a lot of the function of the overseas offices are marketing and promotion. of the SIAC. They're doing a great job.
So unless the parties designate otherwise in their contract, what language are SIAC arbitrations held in?
It will be in English by default. Singapore functions on English by default. It is the language, it's the official language of government. It's the language of our courts. Having said that, Singapore has 4 working official languages, English being one of them. Then there's Mandarin, Malay, and Tamil.
So the parties can specify a language other than English if they so choose, and their arbitrators will be fluent in that language as chosen by the SIAC, correct?
Yes, it can be done.
So talk to me a little bit about the arbitrators. One of what I understand is one of the unique things about SIAC arbitrators is they're really arbitrators from all over the world. It's
Yes.
not, they're not just Singapore-based arbitrators. So how did that come about, if you know how the SIAC roster of arbitrators are, you know, experts from every corner of the world?
Again, I have to say it's intentional. It was one of those things that the movers and the shakers knew that they had to do to make it truly a hub. And so it was intentional to look for the best known arbitrators wherever you were situated in the world and invite you to join the panel. And so it's an intentional building of that panel. It's grown. So in tandem with the rise of the reputation and use of the SIAC, it starts to market itself.
And I assume that Singapore is party to the major rules and conventions governing arbitrations, such as the UNCTRAL and the New York Convention, and so that the advocates will have familiarity with both the procedure and that a Singapore-based arbitration will be acceptable around the world.
Yes, definitely. Even with the drafting of the SIAC rules and its revisions, there's a continuous looking to 2 levels. One, you look internationally and you see what the trends are and making sure that you're right on top of them. But at another level, it's also pushing the agenda of being cutting edge.
So talk to me a little bit about the fees. Are the fees based on number of arbitrators, the amount at issue? Are they all paid to the SIAC, who manages paying the arbitrators, which is fairly standard in the around the world? But are they organized that way in the SIAC?
Yeah, so the fees are fairly transparent. Before you even commence or think about commencing arbitration in Singapore, your 2 primary factors are going to be whether it's going to be a single arbitrator or 3 arbitrators. If it's 3, then you're paying 3 times the amount for your tribunal. You have transparency in the fees of what the SIAC is going to charge to administer the arbitration. And so the second factor that comes into play is the quantum in dispute. So the SIAC, if you're going to be waffly about it, they're going to try and pin you into putting down a number. And if a number becomes more surfaces at a later stage, so you might have a revision of the fees. at that point. So you just enter in the online calculator, and you can figure out what the fees are generally going to be. That's going to be confirmed once the notice of arbitration is sent in and the arbitration proper starts. So that's when they do the formal evaluation, but it'll be fairly close. And then, so the fees can be collected in stages, and it'll be usually shared equally by the parties and paid upfront.
So is it a set fee for an arbitrator, or does each arbitrator have their own separate fee structure?
It is a set fee structure for the arbitrator that the parties will be exposed to. In the background, whether there's a differentiation, the parties will not see that. As far as the parties are concerned, it's fixed.
Okay. So let's talk a little bit about actual arbitrations and some of the differences that I have seen in talking to people who do this around the world. When you file a statement of claim in arbitration, either ad hoc or SAIC, do you in Singapore, do you need to or can you use witness statements at the time of the statement of claim, or is it just a straightforward, here's why we're in front of the arbitrators, here's the issue?
The rules give the tribunal a lot of room in order to set the procedures that they require. So what's mandatory is how you commence, which is your notice of arbitration. And then you have an initial response from the counterparty, the respondent. And then the step of appointing the tribunal starts to kick in. Once the tribunal kicks in, what the rules specify is that there ought to be a series of these kind of steps, but the ins and outs, whether the witness statement comes in together with a statement of claim, that is left to the arbitrator, the tribunal. And but the usual cause, from what I've experienced, is that the answer will be no. That's not usual for the witness statement to come in together with the statement of claim, unless there's a special reason for that. Usually, if parties want to expedite things, and so you don't give that time between the statement of claim and the defense, let people think about it and then prepare their witness statements.
So witness statements are used in Singapore arbitrations and are admissible. The arbitrators will accept a witness statement as evidence. Is that true?
Yes, and also usually if the witness turns up to confirm that statement.
So this is different than how it's normally done in the United States, which is why I'm asking that question. So if a party puts in a witness statement and that witness doesn't show up, meaning that the other side has no opportunity to cross-examine, will that witness statement still be admitted by the arbitrators, or because there was no ability to cross-examine, they will not let it in?
The arbitrator has got the power to decide whether to accept it or not. So before the arbitrator makes that decision, the arguments are going to be heard.
Okay. And have you seen situations where a witness statement is admitted when there was no ability to cross-examine?
Usually when there's not that much dispute about that witness statement.
Okay.
So I've seen both.
Let's talk a little bit about discovery in arbitration. Is it more limited than in the court? Are the rules fairly specific, or is it really up to the arbitrators depending on the issue that's before them?
It's up to the arbitrators, and so I think when we talk about discovery, there's going to be like a range internationally. I would understand that American litigation discovery is very extensive, very invasive. A lot of time and cost is spent on it. Then, of course, you've got the other side swing, which is the civil jurisdictions, civil law jurisdictions, where you only produce what you want to produce, kind of idea. And then you've got the area in between. So notionally, the Americans, you guys got it up from the concept of discovery from the British, but the British is not as extensive as the way that the Americans have done it. I think that in Singapore, we inherited, as far as litigation is concerned, what the British do, but I think we are less liberal, even than the British. And then you come to arbitration, where because of its international nature, it is trying to find a balance between these extremes.
Okay. So let's turn a little bit to the Singapore International Commercial Court, and I probably don't understand it as well as I should, but it seems to be a unique court, at least compared to anything we have. It's a court that's part of the General Division, so it's a judicial court, but it is authorized to hear cases under the International Arbitration Act. Is that correct?
No.
No?
Well, my take on this. So our Chief Justice of the courts used to be, when he was a practitioner, leading arbitrator, leading arbitration counsel, very well known internationally. And then he became the Chief Justice. So as someone with that background, he's well aware of the pros and cons of the different systems. And he certainly felt that there was a need to fulfill this kind of like in between concept between arbitration and going to court. Well, so then as a Chief Justice, he worked within that judicial system. So the SICC is a judicial court with a very international outlook. So we have judges, international judges, who sit on the SICC. We have US judges, British judges, judges from all over the world.
So it's a Singapore government court with judges from other nations on. That's fascinating.
Yes. And and the counsel that can appear before this court can be international counsel. So you don't need to be a Singapore advocate and solicitor to obtain permission to appear before this court. And there is no need for there to be any Singapore connection in the case. So none of the parties need to be Singaporean. the contract, the dispute doesn't need to relate to Singapore in any way whatsoever. So it can have a completely 100% international basis of what it is. No Singapore connection at all. Then you have elements of arbitration that can be invoked in the SICC. So the confidentiality, which a lot of parties, why they choose arbitration is that matters are confidential. You can obtain confidentiality cover in the SICC proceeding. The rules of discovery, the mechanics and the method of it tend to follow what has been common. It is common in international arbitration. So you have this mix of procedures, but within a court environment, because there is a felt need that you have professional adjudicators whom parties are not paying, but they are professional, and so they are in that sense perceived to be thoroughly objective. In addition to that, the first instance decision can be appealed to the Court of Appeal, which again can be constituted by judges within this international panel. So the appellate court, it's a question of trust that you parties want to arrive at a correct legal decision.
It's a fascinating system, and I understand that it is mostly used by bank and financial institutions who maybe don't in their more commercial disputes. Is that not true?
Oh, it's a variety right now. It's doing well. A lot of cases go to the SICC. A variety of cases. Really exciting one was over crypto.
Oh, really?
Yeah.
So,
and that was heard by a British judge.
It really is an amazing. I mean, it is a great example of the government trying to make it easier to litigate in Singapore than in lots of places in the world. Just thinking about it, putting on my litigator hat, or my arbitration lawyer hat, one of the advantages I can see, other than the ones you've mentioned, is I can't get a party into arbitration unless they've agreed to be in the arbitration. However, if I have a dispute in the SICC, the court can add third parties under whatever the Singapore law is that allows third parties to be brought in. At least in the US, that would be an advantage. That would be a situation where, the SIAC might not work, but the SICC might work, so that I could get all related parties in front of the same tribunal. That would be a big advantage in a large commercial dispute, perhaps, or that. And I think it's a fascinating system, and I'm sure there are places that have copied it around the world, but to my knowledge, it's pretty unique. And it's also interesting that it was driven by the Chief Justice. So.
Oh yes, cutting edge. He's a thought leader, definitely.
So we've been talking about all the advantages of using the ADR system in Singapore. I assume there are things that people look at as potential areas for improvements. Can you think of any that when people from around the world look at the SIAC or other, ad hoc opportunities in Singapore, they say that this is an area that we could improve on?
I think Singapore doesn't rest, so it keeps pushing. So for example, for the SICC, one of the issues that you have with a decision from a national court is how enforceable is it going to be in another jurisdiction. So there are efforts made, cross-border diplomatic efforts to create something akin to the New York Convention that helps international arbitration a lot. On the mediation front, no small effort by a lot of powers that be to land on the Singapore Convention on Mediation, which is, I mean, it's all intentional. The SIAC continuously relooks its rules, looks at any weaknesses and tries to work on addressing them. So it's all round kind of effort by the people who are involved on the ground with it, as well as the government support from all levels.
One of the things we hear as advocates outside of Singapore is that the SAIC, the arbitrators are very close knit. They're very tied together, and that you generally can often see the same arbitrators. They appoint each other, and then it's a very hard group to get into, and it needs to expand its scope of panelists. Do you think that's a fair critique of the SAIC currently, or is that something that you think is not a valid problem?
I think it's okay. So I think it's not an issue about the panel or who is on the panel. The panel's very wide, and it's not a question of getting onto the panel. I think it's a question of there is certainly an old guard that can be you do see them quite a lot, whether as counsel at one point and then as arbitrator at another point. Some of them tend have practices of just being arbitrator, but you keep seeing them with appearing when there is a certain counsel. So counsel arbitrator kind of like set. Right. Because the counsel will be influencing the party to try and appoint. Right. So that happens. I think that there's a consciousness of it and efforts being made to, well, I think in terms of where the SIAC is involved in the appointment, to try and appoint outside to give opportunities to younger arbitrators, good but younger arbitrators, to give more exposure. I mean, it's never going to be a good thing for there to be too much concentration within a few people.
So put on your Singapore advocate hat for a minute. Why, if someone comes to you and says, I'm writing an arbitration clause. Why should I consider arbitrating in Singapore? What would be the main things you would tell them? Other than they could hire you and have a really good lawyer working for them. So,
Well, lots of reasons. Singapore's a great place. It's neutral, rule of law. You are absolutely confident that there's not going to be any corruption. The venue is good. Logistics wise, arriving into Singapore, connectivity, it's all very easy. Getting through customs, getting to your hotel, going to a comfortable venue. The food is good. And in terms of the people that you're going to work with, not just me, but everybody else that's going to be involved in the arbitration set, the administration is going to be good. It's going to be professional. You have your free pick of counsel that you want to choose from anywhere in the world, and of course the Singapore set is good as well. And your panels are of high quality, well known. In fact, a lot of the top arbitrators situate offices in Singapore.
thank you. You did a nice job selling the arbitration in Singapore. So we've spent a fair amount of time talking about ADR in Singapore, and thank you for your time. Is there anything you think we've missed that would be important for the listeners and viewers to know?
Singapore is a very, very small place. Literally, we are actually smaller than a dot that you poke onto a map. In terms of relative size, we're really very small, but we're so cosmopolitan, extremely international, multiracial, multi-religious. We are just so open and so international in our outlook. You can come from any country in the world and you'll find somebody in Singapore who knows your history, knows your politics. We just can't afford to be insular about things. We're founded on an international port. That's how Singapore established itself. Why the British were even interested in this tiny island. And we've built on that. We've built relationships all around the world. We're friends with everyone. The lawyers in Singapore network internationally. And yeah, it's just a great. I think we're a nice place to be.
Well, it's very nice that someone is so proud of the place where they live and work. So, Daniel, thank you so much for your time and all the very interesting information about arbitrating in Singapore. I appreciate it. Thank you so much.